Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing with the United States Supreme Court case of United States versus Georgia. This case deals with an inmate who wants to sue for bad prison conditions and wants to invoke certain provisions of federal law that he believes applies. So in this case, we're going to look at the federal law, look at the standards, and see what relief the Supreme Court orders. Let's get started with this. Title II of the Americans with Disabilities Act provides that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, activities of a public entity or be subjected to discrimination by any such entity. The Act defines a public entity to include any state or local government and any department, agency, or other instrumentality of a state. We have previously held that this term includes state prisons, which is certainly logical enough because a prison is pretty much a state instrumentality, yes. Title II authorizes suits by private citizens for money damages against public entities that violate the relevant law. In enacting the Americans with Disabilities Act, Congress invoked the sweep of congressional authority, including the power to enforce the 14th Amendment, which provides for substantive due process against state actors. Moreover, the Act provides that a state shall not be immune under 11th Amendment to the Constitution from an action in federal or state court of competent jurisdiction for a violation of this chapter, an unequivocal expression of intention to abrogate state sovereign immunity. So that is a whole thing unto itself dealing with the 11th Amendment. But in any case, the relevant law is that when the state is immune, unless Congress very explicitly takes away its immunity with respect to a particular federal law. It's complicated and we don't have time to get into it. But in any case, it doesn't matter. In this particular case, in the Americans with Disability Act, Congress very specifically said you don't get state sovereign immunity. So our federal law is a thing that exists and it applies to state actors. And so you can't say, well, I'm a state actor, you can't sue me. It's like, no, because that'd be counterproductive. So yeah, no, you can't say, well, I'm a state actor, the Americans with Disability Act doesn't apply to me. Yes, it does. And if you're an institution of the government in the state or locality, you have to make sure you don't discriminate on the basis of disability. And that includes prisons. All right, fair enough. Let's keep reading. The petitioner, Tony Goodman, is a paraplegic inmate in Georgia prison system who, at all relevant times, was housed at the Georgia State Prison in Reidsville. After filing numerous administrative grievances in the state prison system, Goodman filed a pro se complaint in the United States District Court for the Southern District of Georgia, challenging conditions of his confinement. Goodman's pro se complaint and subsequent filings in the district court included many allegations, both grave and trivial, regarding the conditions of his enforced confinement in the Reidsville prison. Among his more serious allegations, he claimed that he was confined for 23 to 24 hours per day in a 12 by 3 foot cell in which he could not turn his wheelchair around. He alleged that the lack of accessible facilities rendered him unable to use the toilet and shower without assistance, which was often denied. He is a paraplegic after all. On multiple occasions, he asserted he had injured himself in attempting to transfer himself from his wheelchair to the shower or toilet on his own, and on several other occasions had been forced to sit down in his own human waste, while prison officials refused to assist him in cleaning up the waste. So, yeah, it sounds like the prison here is not exactly accommodating him with his disabilities. So I don't know why he's in jail, nor for our present purposes does it matter. But if he deserves to be in jail, so be it. You know, just because you're a paraplegic doesn't make you immune from the law. I think we can all agree to that. So, but that being the case, however, they have to treat him humanely. And he's in a wheelchair. So that would presumably mean that he should be able to turn around in his own cell. That would presumably mean that he need to have bathrooms that would be accommodating to him. And if he needs help, then you have to provide him that help. You know, he is basically at this point a ward of the state. You know, he's under the state's protection. The Constitution requires the government to give him assets because he can't provide those assets for himself. The government does have an affirmative duty to him. And that, it may not be the biggest affirmative duty, but it's something. They have to feed him. They have to make sure that he gets showers and has access to the bathroom and has water and can turn around in a cell. We're not requiring you to do a whole lot, but, bare minimum would be nice. And apparently not so much at this particular prison. So he'd like to sue over that. All right. The district court adopted the magistrate judge's recommendation that the allegations in the complaint were vague and constituted insufficient notice pleading as to Goodman's 1983 claims. It therefore dismissed the 1983 claims against all defendants without providing an opportunity to amend. So they dismiss it with prejudice, saying your complaints are bad and you should feel bad. They are so bad that they don't tell the prison what they did wrong. Now, the fact that they didn't give an opportunity to cure is somewhat notable here, because you would think that they did, but they didn't for some reason. All right. The 11th Circuit determined that the district court had erred in dismissing all of the claims because Goodman's multiple pro se filings in district court alleged facts sufficient to support a limited number of Eighth Amendment claims under 1983 against certain defendants. So the Court of Appeals takes a look at this and says, well, if you're going to dismiss a count, that's fine. You have to dismiss each count on its own terms or not. And so some of these claims certainly are garbage, fine, but he's presented enough material that some of these claims are not garbage. Now, maybe they're not presented in the right way. That's totally possible. But the remedy there is give him an opportunity to cure. So either just give him an opportunity now or dismiss without prejudice for those claims or whatever. But if there's enough evidence to suggest it, you shouldn't dismiss it out of hand. All right. The court remanded the suit to the district court to permit Goodman to amend his complaint while cautioning Goodman not to reassert all of the 1983 claims included in his initial complaint, some of which were obviously frivolous. So the Court of Appeals is just kindly, making clear that because some of your claims are valid doesn't necessarily mean they're all valid. And some of them are decidedly not valid. So you have permission to amend as to the claims that are remaining. But if you try to sneak those other ones back in, we're going to be displeased. So please take note accordingly. And then the Supreme Court gets to what their function is here. We grant certiorari to consider whether Title II of the Americans with Disability Act validly abrogates state sovereign immunity with respect to the particular claims at issue here. So we know that there's a general waiver, but of course, like everything in law, it's very fact-specific. So we need to figure out if there is a waiver of state sovereign immunity with respect to these particular claims, because if there's not, then there's no cause to amend because there's no possible legal basis to go forward. So figuring that out would be pretty important. While the members of this court have disagreed regarding the scope of Congress's prophylactic enforcement powers, which is preemptive in nature, so we're going to do something to prevent something from arising in the first place. So there's some doubt maybe there as to what Congress can do proactively. No one doubts that Section 5 of the 14th Amendment grants Congress the power to enforce the provisions of the amendment by creating private remedies against the states for actual violations of those provisions. So maybe or maybe not with the hypothetical ones, but actual ones, sure. Section 5 authorizes Congress to create a cause of action through which citizens may vindicate its Fourth Amendment rights. So yeah, Section 5 of the 14th Amendment says Congress has the power to enforce this amendment through appropriate legislation. And one of the things Congress could do is allow private individuals to sue for violations, right? They don't necessarily have to. It could be that only state government actors or only the federal government could bring a complaint or something. But for whatever reason, Congress decided to allow individuals the right to sue for the Americans with Disability Act, which I suppose is fair enough. And so, yeah, you can sue if there are actual violations. Okay. From the many allegations in Goodman's pro se complaint and his subsequent filings in the district court, it is not clear precisely what conduct he intends to allege in support of his Title II claims. Because the 11th Circuit did not address the issue, it is likewise unclear to what extent the conduct underlying Goodman's constitutional claims also violated Title II. So, did it violate the Eighth Amendment is one issue. cruel and unusual punishment? Did it violate the Americans with Disability Act? Potentially separate issue. So we're not clear to the extent that you're saying this is an Eighth Amendment problem versus an Americans with Disability Act problem, because they're separate things and have to be analyzed separately. Moreover, the 11th Circuit ordered the suit be remanded to the district court to permit Goodman to amend his complaint, but instructed him to revise his factual allegations to exclude his frivolous claims, some of which are quite far afield from actual constitutional violations under either the Eighth Amendment or some other constitutional provision, or even Title II violations. So some of this stuff, none of those things. Some of this stuff is not ADA or cruel and unusual punishment. Fair enough. Once Goodman's complaint is amended, the lower courts will best be situated to determine, in the first instance, on a claim-by-claim basis, which aspect of the state's alleged conduct violated Title II, to what extent such misconduct also violated the 14th Amendment, and this would be by way of the 8th Amendment incorporation. So, like all incorporation doctrines, they're all through a substantive due process. So it's the 8th Amendment incorporation of the 14th Amendment incorporation of the 8th Amendment's cruel and unusual punishment clause. So that's what they're talking about there. And insofar as such misconduct violated Title II, but did not violate the 14th Amendment, whether Congress's purported abrogation of sovereign immunity as to that class of conduct is nevertheless valid. So did Congress intend, with respect to prisons, because this is prison specific, did Congress intend to go further than the Eighth Amendment would require? Which is definitely something Congress can do, right? The Constitution and the Bill of Rights sets floors, not ceilings. So it's a line below which Congress cannot go. But Congress certainly, if they were so inclined, could go further. They could give you more rights. That would always be fine. So one of the things we have to analyze is, well, did they give you more rights? And in so much as they did it apply in prisons in a way that would go to their sovereign immunity? So all those answers can be analyzed in the first instance below. Thus, that brings us to the end of the case of United States versus Georgia. In this case, the Supreme Court of the United States looks at the issue in Georgia prisons and the issue of a paraplegic, handicapped individual whose conditions seem to violate potential provisions of the Americans with Disability Act and or the Eighth Amendment. However, his complaint was not sufficiently clear because it was pro se. So he didn't know what he was doing, which, understandable, but they still have to be sufficiently clear. So the district court smited him and said, go away. And the Eighth Circuit Court of Appeals said, let's give it another shot. And the U.S. Supreme Court says, well, we're not 100% sure if Congress intended, when it passed the Americans with Disability Act, to allow more than the Eighth Amendment would require. So does this violate the Eighth Amendment? We could probably just stop the analysis. But then the question is, if it doesn't violate the Eighth Amendment, but does violate the ADA, did Congress intend to waive or abrogate sovereign immunity as to those particular claims? And we don't know. So those have to be analyzed below. So we're not going to figure it out today. The Supreme Court doesn't like to figure out stuff on the first instance if they don't have to. So in any case, this gets remanded for further considerations, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.